Merry Christmas to all. Good morning and welcome everyone to our AABN's 107th weekly webinar. AABN webinars were created in response to COVID-19 related lockdown. Conducted from June 2020 to present, the webinars are the result of a partnership between AABN Entrepreneur Network, Alma Mater, and industries institutions. AABN webinars provided entrepreneurs access to real-life examples of possible career paths and the opportunity to have fun interacting with others outside their home in a safe way. These webinar series are designed to help aspiring entrepreneurs visualize the possibilities, identify resources to support their vision, and understand the logistics of starting a business. This Sunday too, you would be delighted to know that we have an eminent guest speaker, Mr. Christopher Manoharan, and he will share his thoughts on the unraveling of the Indian data protection law in this interactive business networking session. Data protection refers to the set of privacy laws, policies, and procedures that aim to minimize intrusion into one's privacy caused by the collection, storage, and dissemination of personal data. Personal data generally refers to the information or data which relate to a person who can be identified from that information or data, whether collected by any government or any private organization or an agency. After the withdrawal of the earlier Personal Data Protection Bill 2019, the Ministry of Electronics and Information Technology has released a new Digital Personal Data Protection Bill 2022, which adopts a more simplified approach to handling personal data in comparison to its predecessor. The Digital Personal Data Protection Bill covers several key principles pertaining to lawful usage of personal data, limitation on collection of personal data, data minimization, data storage, and accountability of the person processing personal data. Knowing who to communicate within the organization, aligning legal with other functions, and finding practical and timely external advice are now more important than ever. And with the trend towards remote working, the risk businesses face is set to grow. This webinar brought to you by the core committee of AABN is designed to provide professionals and business owners with the essential knowledge on the Digital Personal Data Protection Bill. I have the present duty of welcoming and introducing Mr. Christopher Manoharan today at the unraveling of the Indian Data Protection Law, an interactive business networking session. Christopher is a senior partner at Kochar & Co, advocates and legal consultants. Christopher is a 1994 graduate from the National Law School, Bangalore. He subsequently obtained his Masters of Law from the Annamalai University. His practice focuses on corporate commercial transactions, venture capital and private equity transactions, joint ventures, trademark litigation and trade execution, large information technology, outsourcing deals, licensing agreements, commercial real estate employment law, and government policy. In addition, Christopher is involved in litigation and has been acting for clients before the NCLT and the NCLAT Chennai. In his role as a transactional lawyer, he has had substantial experience handling early stage investments in venture funding and private equity, in joint ventures and technical collaborations. In his in-house counsel avatar, Christopher's role spanned multiple sectors such as manufacturing, information technology, venture capital, and financial services. During this period, he was advising senior leadership on litigation strategy, especially in employment law matters, commercial disputes, and trademark disputes. He was also instrumental in creating handbooks related to employee policies, data privacy and security, confidentiality, intellectual property protection, and zero tolerance harassment policies. He actively assisted clients in the areas of corporate governance, regulatory risk and mitigation strategy, compliance advisory, and carrying out regulatory audits for large corporates was an essential part of his repertoire. His areas of expertise are employment law documentation and litigation, early stage and private equity investments, IT outsourcing and licensing agreement, trademark filings and litigation. Christopher's expertise also centers around proceedings before the National Company Law Tribunal and the National Company Law Appellate Tribunal, Chennai, where he appears from time to time. Without further delay, I would like to open the floor to Mr. Christopher Manoharan, whose hard-hitting experience are bound to inspire and guide us. His is the story of a dream that turned into reality only because of his passion and his grit. Once again, a very warm welcome to you, sir. We are truly privileged to have you deliver the speech today. Thank you, and over to you, Mr. Christopher.
Thank you, Mr. Gopi, for having me here. I'm really honored and privileged, and also the fact that all of you are alumni of Annamalai University, of which I'm also a part, really gives me a special honor to be with all of you. So thank you so much for having me here. So you know how important the data protection law is and how important it is to protect our data privacy. So I will be talking from an unbiased perspective. It is not from an industry perspective or from even a governmental or so there are three basic players in the data protection environment. One is the organizations, the social media organizations and the data processing organizations, which are normally called fiduciaries. You have on the other side, you have the regulatory authorities, regulatory agencies, the government, and you have data principles, which are you and me. So I will actually be looking at it from the point of view of a data principle. And can you hear me? Am I audible? Hello? Hope I'm audible.
You're audible. You're audible.
Yeah. Okay. So, so I'll be looking at it from the point of view of a data principle, and I will be talking about this from the point of view of an Indian lawyer, not really so much from the point of view of the global data protection laws. Although the current data protection bill that we have in place largely mirrors the GDPR, or the General Data Protection Rules of the European Union. I will be competent to speak only about the data protection bill as far as India is concerned. So with that, let's get started. I'm happy to have you all on board. So I'd be happy to take questions, as Mr. Gopi said, at the end of the session. So please make notes and please ask me wherever you have any issues at the end of the session. So what the agenda for today is, we have the important timeline which we will look at initially. Why is data protection important to us? What are the key concepts with respect to data protection law in India? And penalties form a very major part of this whole journey on data protection. So we need to discuss that as well. So the important timelines are as follows.
Sir, is there background noise coming at the coming?
Yes, Mr. Gopi?
Is there
I think its audio has some problem.
You're not able to hear me? Okay.
We are able to hear you. The thing is, when you talk, like some disturbance is again happening while you talk alone.
Background noise is coming.
Okay. So probably I need to hand off, I think. Or just let me see. Put on the speaker. Hello, Gopi?
Yeah.
Hello?
Yeah, we can hear you now.
Hello, Mr. Gopi?
Yes, sir, we can hear you, sir.
We can all hear you, Christopher.
You can hear me now? This is better?
Yeah, it's better now. We can
We
hear you.
We can hear you,
Okay.
but there is a lot of noise. It's going to just disrupt the whole procedure today. We cannot hear you clearly. Whenever you speak, there is a background noise. It's like somebody is beating a drum with a bucket. So it's something to do with your audio. I just think everybody should be on mute.
So is this any better? Are you able to hear me now?
So we are able to hear, but there's some background noise which is coming in as you talk.
As I talk, okay. It's only when I talk the background noise.
Microphone. The problem should be with your microphone below.
But it is only when I talk you get the sound, right? When I don't talk, you don't get the sound, right? The background
Yeah.
sound.
Yes, yes, when you talk.
Okay, okay. So I guess it's to do with my microphone. Do you want to give me a couple of minutes? I'll probably change my laptop. That might work. 5 minutes? Or do you want to continue?
Please, please, please.
Should I change the laptop?
Yeah, please, 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 please.
Okay, okay, okay. Mr. Gopi, can you allow screen sharing for me?
Yeah, I'll do that. I'll do this. I'll do this. Bala, can you just make him a co-host again? Done, done, sir. Done, sir.
Can you see my screen?
Yes, sir. Yes, sir. Please go on, sir.
Hello?
Yeah, we can.
Is this any better? Are you able to, is there any vibration now or anything?
No, it's clear. It's clear. It's clear. You can
Right?
proceed, sir.
Okay, okay. Thank you so much. So, guests, again, welcome today. Welcome to all of you. And Christmas wishes to all of you on this good and nice morning. So, we're talking about the unraveling of the Indian protection law. And as I said, I will be talking about this purely from an Indian point of view, from an Indian law perspective. I'll be happy to take questions towards the end. So the agenda for today's meeting would be discussing about the important timelines that have taken place till now. Why is data protection important for all of us? What are the key concepts that we'll be looking at? And of course, penalties, because they form an important part of this travel on data protection. So April 2011, the Information Technology Reasonable Security Practices and Procedures and Sensitive Personal Data Information Rules was notified. This was notified under the Information Technology Act. This laid down the important parts of what actually information is about, what actually data, actually private SPDI, that is sensitive personal data or information, SPDI is about. We will be discussing about this later in this session. So in 2017, a 10-member committee was set up under the retired Supreme Court Judge B.N. Sri Krishna to examine the need for the data protection law in India. So, just the rules under the Information Technology Act was considered insufficient by a large majority of the industry. And just like how it was in Europe and in England, the audience, that is the business industry, wanted to have a specific enactment on data protection. So a 10-member committee under the retired Supreme Court Judge B.N. Sri Krishna was set up to examine the need for a data protection law in India. Around the same time, in August 2017, there was a case in which there was a 9-judge Supreme Court decision in which the right to privacy was declared a fundamental right. In December 2019, the Protection of Data Privacy Bill was tabled in the Indian Parliament by the Ministry of Electronics and Information Technology. This bill was widely criticized as giving unencumbered power to state agencies like the Enforcement Directorate, the Central Board of Investigation, and various other agencies of the government, because it exempted them from the provisions of the bill. So this bill was withdrawn in August 2022. So just to give you a gist of what exactly happened, this bill actually had provisions which empowered the government agencies to track the private information of individuals on an unencumbered basis. So they didn't need to take the private employee's consent. They didn't need to look at areas on which the private person's information had to be gathered. They could just go ahead and track the private information of the person. It could be anybody in the government or elsewhere. So that kind of unencumbered power that was given under this data protection bill was widely questioned and criticized. So in December 2019, to allay these concerns, the Parliament decided to form the Joint Parliamentary Committee comprising of 30 members from both houses of Parliament for further examination of this bill. And at that point in time, the Joint Parliamentary Committee suggested that the bill should include both personal and non-personal data. Now, what is personal and non-personal data? We'll be discussing this as we go along. Now, this Joint Parliamentary Committee looked at the bill and came out with almost 81 suggestions as to how the bill needs to be overall. Now, up to here, what basically happened was the data protection bill was only constantly being reviewed and was being, plugged in with various improvements and with various, changes that had to be done from a purely cosmetic perspective and from a purely presentation perspective, I should say. So, it was like trying to repair a old house which was, badly in need of repairs. However, what the JPC thankfully did was it came up with a completely different law this time. From scratch, it came up with a law which was very clear, which didn't have more than 40 provisions, which had lots of illustrations on what the law actually set out to do. And now this bill, which we call the new revamped data protection bill, has been tabled before Parliament. The bill was up for public consultation up to December 17th. Various industry bodies, the general public, and various government agencies have come up with a lot of recommendations which have actually gone into the system. The final version is expected to be tabled in the budget session of the Parliament next year. Now, we need to know why such a big hullabaloo is being created about data privacy and why it is important for our lives. So, we are in the age called Industry 4.0, and we are looking at lots of emerging and critical technologies during this era. So what are the important and critical technologies that we are constantly looking at, which are emerging and which are going to emerge? Artificial intelligence, robotics, big data, 5G communication networks, the Internet of Things, and neural networks, and a lot of technological innovations that are going to come up in the area of telecommunications. So these are going to be the pathways of critical data in the coming days, weeks, months, and years. So why is data important? Data is important because it flows into all the spheres of your life. It flows through the various networks, both in the tangible and intangible spaces. It is called the new oil and the new gold. It comprises of personal data and non-personal data, both of which is monetizable and highly valuable. Now, we were speaking about personal data and non-personal data. Let us first talk about personal data. Any data that can be used directly or indirectly to identify the individual behind the data is considered as personal data. So just to give you a very small example, if there are a group of people in a particular organization who are working on a particular field, and if they all belong to one particular nationality, and there is one specific person who is belonging to another nationality, you want to know the name of that particular person. Just having the names in front of you will not give you an idea of who that person is. However, if there is something like a nationality also coupled with that particular name, for example, if there is a Charles who is from the United States, there is a Thomas who is from say Kenya, there is a Santosh who's from India. You want to know who's Charles. By looking at the table, you wouldn't know who Charles is because it could be any of the faces. However, if you're going to put a nationality to that person's name, then you know that Charles is from America. You put a nationality to the person's name. The moment you see that person, that person is from America. The moment you see America, you will know that this person is Charles because you know that he's from America. And the moment you say America, you know that this person has come from America. So you put two identification points together to identify a person. So that's why indicators like nationality, name, phone number, email ID, location, home address, work address, banking details, IP address of the device from which you are accessing information can all be used to identify the individual behind that data. So the SPDI, which is under the IT rules, which is still there, clearly states that you shouldn't put data in a form that is able to identify individuals. And that kind of an arrangement of data is obviously illegal. So what is this information used for? This kind of information, the kind of information that is normally used for profiling a person could be sex, date of birth, physical attributes, health conditions, stocks you hold, the food you like. You could also be profiled on the basis of your sexual orientation, religious beliefs, and political beliefs. Now, why is this important? From a positive standpoint, this kind of a personal data that you have, which is able to actually identify who that individual is, can be used for targeted marketing to give you a better customer experience. It can help to create better products depending on the feedback that you get from these targeted groups. In terms of the negatives, it could be used for racial profiling. It could be used for religious and political discrimination. Now, why is this separation of personal details from your preferences and choices important? Because then once you're able to separate, once personal details, the personal identification criteria is separated from your preferences and choices, that becomes anonymized. That information becomes non-traceable. So this kind of information, which is non-personal and which cannot be actually attributed or traceable to a particular person, is the kind of information that is both valuable and useful to society. Now, just to give you an example, this anonymized information, this non-traceable information, which is separated from the information that is gathered, for example, by a food delivery app, this can be used to, this can be used to give you a better customer experience. So this information is used to track the determination of the peak ordering time. What is your most preferred food item? What is the preferred restaurant from which people are normally ordering food? So, this and many other criteria of information is normally gathered. This could also be further broken down into gender, age, locality, in order to find out what kind of people are ordering what kind of food from which locality. So all of this helps the food delivery app owner to understand the kind of information he has, to understand what he has, to be able to provide a better customer experience to the people around him, and of course, to be able to compete very well in the business. So, as I said, the non-personal data can, you normally segregate this kind of information so it doesn't hit your, it doesn't hit the kind of business that you're doing. So the non-personal data is normally organizational data, data on deceased persons. This could be from an historical perspective to see what people were doing in a particular time frame. What are their physical attributes, their health conditions. This could also be important in terms of non-personal data. What are the health conditions of people, and you always have these health conditions which you put into your fitness app, So everything about you is already there. So how exactly is this going to get used? Is an important aspect of trying to use non-personal data in a manner that is going to be useful to you. The stocks you hold. So in terms of understanding, what kind of stocks people hold, and how is it that you can sell stocks to people and make it more attractive for them, is also an important thing. This actually belongs to the financial world, and they come up with various permutations and combinations on with respect to this particular aspect. And as we said, the issues like sexual orientation, religious beliefs, and political beliefs do not find a place as far as non-personal data is concerned, because non-personal data is mostly engaged in economic growth and in ensuring a competitive sphere of activity for the player. So we come to the content for our discussion today. We will be talking about the concept of personal data. What exactly is concept of personal data? We have till now we've seen, as you know, why is data important? Why is personal data important? Why is non-personal data important? Now, how does the law seek to regulate these particular aspects of data? What is the concept of personal data? What is the applicability of the data protection bill as it stands today? The three main actors under this bill: the data principal, the data fiduciary, and the data processor. So we'll be looking at that. We'll also be looking at the rights and obligations of each of these actors. We'll be looking at cross-country data transfer and data breach. Now, what is personal data? As I said briefly, personal data means any data about an individual who is identifiable by or in relation to such data. So if you are able to combine the data in a manner that is able to identify that particular person, then that data becomes a personal data. Otherwise, that data remains as an anonymized data. Now, this kind of information was considered as a sensitive personal data or information under the IT Act and rules, and still it is, because it is not got these rules under the IT Act is still not got overruled. And this required a greater degree of care, including information like biometric data, health records, financial records, sexual preferences. All this was a part of the sensitive personal data or information under the IT rules. Even as it stands today, that is the requirement. So there is a huge requirement for consent. So this information cannot be shared with anybody unless you have the consent of the data subject, as it is called under the current SPDI rules. And here you call the person as the data principal. So the purpose for which the information is going to be used has to be revealed to the person who is giving that information, and there should be consent from the person who is giving that information. Otherwise, you will not be able to use that information. Now, this information should only be used for the purposes which is beneficial to the individual. That is one thing. The second point is that whenever you're going to share this information with anybody else, then you need to again go back and seek the person's consent. So there are two aspects of consent. Firstly, when you receive the information from the person who is giving you that information, and second, when you are going to share that information with a
Google Meet.
I'd like to everybody to mute their speakers, please, if you don't mind. So the requirement for consent and retention was very primary, very important under the SPDI rules. Now, to a large extent, this is a little watered down, probably after all the consultations that are taking place, after all the receipt of suggestions that are taking place, these things will get watertight. But in the current scenario, the requirement for consent and retention of information have got diluted to a certain extent. Now, who does it apply to? The data protection bill as it stands today, the data protection bill, which has not yet become an act, is applicable to anybody within the territory of India. So it could be even a foreigner who has come to India. So when a foreigner, probably US national who is in India, has certain health complaints and discloses some information regarding his health to the hospital authorities. Can you hear me? Yeah. That information would be considered as data for the purposes of the bill. So within India, you have the processing of digital personal data, which is collected online or offline from data principals. So all kind of information which you consider within India, either online or offline, which are from data principals within India, that is you and me are data principals because we are the ones who give the information, will be covered under the data protection bill. Outside India, the processing of digital personal data undertaken for the purpose of profiling, offering goods or services to data principals within India. So as long as the data principal is within India, you take his information out and process it in any of the intermediary organizations outside. That will also be considered as data processing for the purposes of the data protection bill. Now, where is the data protection bill not applicable? It is not applicable to non-automated processing. So if you have information which you are just processing manually in the form of notebooks, in the form of information which is not automated, it will not apply to it. It will not apply again to offline personal data. It will not apply to any of the registers you're maintaining. It will not apply to any of the other paper documents that you're maintaining. It will not apply to personal data processed for personal or domestic purposes by an individual. So if you're giving that information to somebody else who's an individual, and he is only using it for your own personal purposes, he's not using it for an economic for a commercial purpose. He's only using it for your particular purpose, then it would not be considered as personal. It would not be considered as data falling under the purposes of the data protection bill. If it is information that you're using for domestic purposes, it will not be considered as data protection for the purposes of protection under the data protection bill. It will not records containing personal data that have existed for at least 100 years. So if it is information which goes back in time, again, that will not be considered as part of the information under the data protection bill. Now there are three main actors under the data protection bill. These three main actors are the data principal, the data fiduciary, and the data processor. Now, the data principal are people like you and me, to whom the personal data relates, and where such individual is a child, it includes the parents or lawful guardian of such a child. The data fiduciary is an entity that determines the purpose and means for processing the personal data. Now, the data fiduciary is an organization that gives your personal data to the data processor, who processes the data on behalf of the data fiduciary. Now, let us go a little more in detail into who these people are. Now, as you said, the data principal are people like you and me. Who is the data fiduciary? Once we look at this, we will understand who the data fiduciary is. The data fiduciary is the organization which collects your information and holds it in trust for you and cannot share it to anybody else without your permission. So that is the basic premise of a data fiduciary. Now the data fiduciary sometimes acts as the data processor also, but sometimes passes on the information to the data processor for a specific purpose, and the data processor then uses that particular information to be able to either speak to you or get more information or carry out certain acts. So you could have a situation where you give your information out to the bank, and the bank collects your information and acts on your behalf. The bank is beholden to keep your information confidential. The bank cannot share this information with anybody else. But at times, the bank have these huge data processing centers, which they have for the purposes of giving out loans, for the purposes of asking people to invest. So the bank doesn't do it directly. The bank gives it to either its subsidiary or to another organization, which then contacts you with respect to certain other activities they want to carry out with you. So that particular organization which is actually contacting you is the data processor, because it is using your particular information for a particular purpose. Sometimes the bank itself might do it, in which case the bank becomes both a data fiduciary as well as a data processor. So there are certain aspects under the new data protection bill which we need to take note of, which did not find a place in the IT Act and under the rules, and which seems to be pretty onerous from an organizational point of view. So here, the organization, the data fiduciary, has to send an itemized notice. Now, what is an itemized notice? The itemized notice will have to say what data is being collected and the purpose for which such data is being collected. And that notice has to not only be given to a particular group of people. You just can't send that notice out to a group of people saying whenever you're seeking information, you just send this information out. For example, if your information is being collected by a hospital, the information is only for the purposes of ensuring that they give you good medical treatment. So then the hospital should, in that notice, mention the reason for which the data is being collected, what data is being collected, and the purpose for which this data is going to be used. Now, if this notice is going to be sent to different patients, you cannot have the same notice going out to different patients. One notice would be to a particular patient for the purposes of understanding what kind of a treatment he should be given for one particular kind of disease. Another notice would be to another patient to understand what treatment he is going to get for that other particular disease. You cannot send out a generalized notice saying that this information is being collected for the purposes of treating you for your illness. You will have to specifically say why that notice is being sent, what is the purpose of the collection, what and how exactly that information is being used for the treatment of that particular disease of that particular patient. You cannot give a generalized notice for everybody. So there could be a patient who is suffering from cancer, there could be another patient who is suffering from a skin issue. So each of these notices will have to be specifically customized for the need of that particular data principle. So to this extent, this becomes very onerous. Now, this particular provision in the bill seems to have retrospective effect. So even with respect to information that has been gathered in the past, how exactly this is going to be dealt with for people who are given this information in the past, so that they are not general information but very specific information, is something that we uh, that the organized industry wants to know right now. So there is no clarity on this. The other obligation of the data fiduciary, as you all know, after the notice is sent with such specific details, there is an obligation to obtain consent. So this consent should be freely given. It should be specific, informed, and unambiguous, and it should be an indication of a clear affirmative action. So it should be an informed and unambiguous indication of a clear affirmative action, which signifies agreement to the processing of personal data for the specific purpose. So you just cannot have something which says that you go earlier. There was a website where you can go and say I agree, and once you submit that button, you are able to give your consent, and once you give your consent, they start collecting your information. Now there has to be a specific, clear, affirmative action which signifies agreement to the processing of the personal data for the specific purpose. So to that extent, it has to be very clear affirmative action. The person has to actually say, yes, I agree to the collection of information for this particular purpose. I understand this information is going to be used for this particular purpose. In case it is a hospital, it's going to be used for treating me, and I understand this will not be shared with anybody. To that extent, I provide my consent. If you're going to share that information, you need to again go back to him and say why you're going to share that information, and again you have to seek consent. So consent has become very onerous and very specific. The data fiduciary needs to the data fiduciary needs to allow the data principal to access such requests for consent in English or any language specified in the 8th schedule. So unlike earlier, where you could have somebody in the vernacular just go and submit press an I submit button in a language he doesn't understand. Now you will have to actually make the person who is providing that consent understand what he is giving the consent to. So that again makes it very onerous on the organization to ensure that the person who is giving that consent knows the purposes for which he is giving that consent, and then presses the submit button or signs on a consent form. Deemed consent. The collection or processing of deemed consent is necessary or voluntary and reasonably expected. The consent shall be deemed to have been obtained. Now, in certain cases, deemed consent. So you need to have a provision where there is deemed consent as well. So, for example, if you're an employee and your information is required for the company to give you certain benefits, or to transfer the salaries into your account, or to give you certain specific medical benefits, you give a consent at the initial initial part of your employment process. When you are getting actually appointed in the company, you give your consent, and after that there is no requirement for the company every time to come to you and say that we need your information for for creating a salary, we need your information for giving you medical benefits, we need your information for this, that, and the other. So there's no need for the company to come to you every time that the consent is required. But these are again in very specific circumstances. This cannot be generalized. This can only be given in situations which really require the which really cause a kind of pain area to both the data fiduciary as well as the person who's giving the consent, to be repeatedly giving the consent every time a data processing has to take place. So it is in those very specific instances that deemed consent is taken into consideration. there is also something called the significant data fiduciary under the data protection bill. Now, what it is has not really been defined, but the central government may notify any data fiduciary or class of data fiduciary as a significant data fiduciary on the basis of certain facts. This could be on the basis of the volume and scale of personal data that is being processed, the risk of harm to the data principal if that information is leaked, the potential impact on the sovereignty and integrity of India in case of breach of the information, a risk to the electoral democracy, security of state, public order, and such other factors as it may consider necessary. Now, in all likelihood, you have these large social media giants who will definitely be coming under the definition of a significant data fiduciary, because they have information which government agencies are willing to leverage upon. Now, the government agencies might be wanting to leverage on this data for activities which are beneficial to society by trying to find out what are the likes and dislikes of particular individuals. Or they could be leveraging on this data for reasons which may not really be beneficial to the data fiduciary, to the data principal and to the society at large. So the purposes for which this information may be accessed could be both positive and negative. So in that sense, as a data fiduciary, that particular body is subject to certain additional restrictions and regulations. What are the additional obligations which are applicable to such a data fiduciary? We have the data protection officer. So a data protection officer has to be identified by the data fiduciary. The data protection officer will be a person who is almost like a grievance redressal officer within the organization. In fact, he is a grievance redressal organization who will be looking at various kinds of complaints which are received from the data principals with respect to how the data has been treated, and try to provide solutions by trying to redress the grievance of that particular data principal. There is an obligation to appoint an independent data auditor. The independent data auditor will be analyzing the data which is coming in, and he in turn is going to be, he in turn will be providing answers to the government agencies and to the data fiduciary with respect to any kind of questions which may be asked with respect to the kind of analysis which comes up from the data. There is also a need to take up a data protection impact assessment and periodic audit to see how well the data within the data fiduciary, significant data fiduciary, is being organized, is being used, whether there are any leakages, whether the information is being used in a manner that is beneficial to the people around, and whether there has been any impact on the people who have given in the information. The other key concepts with respect to data fiduciary is basically that cross-border data transfer. Now, what is cross-border data transfer? The central government may notify countries or territories outside India to which data fiduciary may transfer personal data in accordance with the terms and conditions. Now, as far as the transferring of data outside the country, there is a schedule that will be provided under the bill, under which the notified countries or territories outside India will be provided. And it is only to these countries or territories outside India to which the data can be transferred. So until such time that the countries or territories outside India has not been notified, the data fiduciaries will not be able to transfer any data outside India. Now, this is where there is a clear sense of angst among the people in the industry. So the industry has been talking to the government on ways and means of ensuring that there is cross-border transfer of information seamlessly. Why is it that the central government is a little finicky or is a little fussy or insecure about the transfer of information outside India? For one, if information about you and me is kept in a foreign country, the central government will not be able to access that information. It could be for either positive or negative reasons, but it will not be able to access that information. The central government would like to keep that information within India. So the central government has now been suggesting that a copy of all the information that is kept abroad is kept in India as well. So this has not been finalized as yet, but might become a reality. So that is one aspect. As regards the data fiduciaries, for them, it makes a lot of economic sense, a lot of business sense to keep the information in foreign territories. Why? Because the temperature there is a lot more conducive to keeping these large servers, which generate a lot of heat and which require air conditioning in order to keep it cool. So in a tropical country like India, it means a lot of cost. So that is the reason why these data fiduciaries would like to keep our data abroad. So for data fiduciaries, they look at it from the point of view of their economic benefit, their economic viability, as well as from the point of view of keeping the data of the data principals private, because they are also acutely aware of the fact that if the data is kept within the territory of India, there is always the risk of surveillance which the government may impose on them. Data breach. Now, organizations need to adopt reasonable safeguards to prevent personal data breaches. Under the earlier SPDI rules, which is actually still in force, you have the ISO, ISCC standards, which have to be followed by various organizations in order to ensure that the data protection is carried out effectively and data doesn't leak. So there is no such kind of standard under the new bill, but I'm sure there'll be some kind of a standard that will soon be put in place. Data fiduciaries are required to report any data breach of data protection to the Data Protection Board of India and all the affected data principals. So the time within which this information has to be reported is not very clear. You have the GDPR, which has a specific time frame within which the information should be reported. You also have certain other rules within India under which which provides for the reporting of this kind of breach to the government within a specific time period. But here there is no time period that has been mentioned. Normally it is about 24 hours to a week at the maximum, but here there is no time period that is mentioned. So we are sure there will be some time period that will be mentioned in the data protection bill. What are the other key concepts with respect to data protection? A data fiduciary must cease to retain personal data as soon as it is reasonable that the purpose for which such personal data was collected is no longer being served by its retention. Now, for example, if your data has all your data is there in the Facebook app, after you log out of Facebook for whatever reason, that information should not continue to be used by the data fiduciary. So that information should be completely expunged. If for any reason that information has to be kept for any legal or business purposes, the data principal has to be informed about it, and only then it should be kept. Otherwise, that information must be expunged. Now coming to this interesting portion on penalties. If the fiduciary, data fiduciary, or the data processor fails to take reasonable security safeguards to prevent personal data breach, the value of penalties can go up to 250 crores. Now, one thing we need to understand penalties is this: under the new bill, all the penalties have been decriminalized. So there is no imprisonment for any breach of the data protection bill. However, the kind of penalties that you can see on the left are very steep, so steep that they can even shut down organizations. So again, the industry is very upset about this, and they are in talks with the government. In fact, suggestions have already been given to dilute the penalties and bring it to a level which is tolerable for the industry. So the penalties could be up to 200 crores in case of a failure to notify the board and affected data principals in the event of a personal data breach. So, as I already said, timelines have been mentioned under the SPDI and even under the GDPR, but there is no timeline that has been mentioned under the current bill, which needs to be taken into consideration by the government. There is a non-fulfillment of additional obligations in respect to children. So, with respect to children, the kind of information that is taken from them obviously has to be with the supervision of the guardian. And if it is not taken with the guardian's supervision and the guardian's consent, then there could be a huge penalty leviable, which can go up to 200 crores. There is also a penalty of up to 150 crores in case of non-fulfillment of additional obligations of the significant data fiduciary. So what are the additional obligations is what we saw. So, with respect to creating a post for the data protection officer, data protection auditor. So these are the various additional obligations. If those are not done by the significant data fiduciary, then there is a penalty of up to 150 crores. Non-compliance with duties of the data principal. So the data principal also has certain duties. The data principal, that is you and me, when we have when we're giving information, we need to ensure that we consent to the information that we're giving, and we need to ensure that we need to keep a track that the information is being used for certain purposes, for the purpose for which it was given. We need to keep our eyes and ears open. But that is really the obligation of the data fiduciary. But with respect to the data principal, if there are certain contracts that need to be entered into between the data principal and the data fiduciary, and if there are conditions in that which are not adhered to, then there could be an issue for the data principal. So there, of course, the penalty has been kept pretty low. It is only rupees 10,000. And non-compliance with any other provisions. Again, this is a very omnibus provision. We do not know what are the kind of non-compliance that this would arise. The industry is up in arms with this particular provisions also. And here the penalty is again a steep rupees 50 crores. Now, so I think so I'm coming to the close of my presentation. Thank you very much for a patient hearing. I'm happy to answer your questions. Thank you so much. Hello, Mr. Gopi, are you there? Hello, Mr. Gopi, are you able to hear me? Hello.
Gopi?
I'm open to questions. So please, I'm happy to.
Yeah, this is Thiru here. So first of all, thanks for your presentation. Who decides on the significant fiduciary? How do we decide that this is a significant?
Yeah, there will be a notification obviously by the bill. So right now there is we don't have any information on how this is going to be done. But yes, there is going to be some information, I'm sure, I'm sure it will be captured as a part of the new act. So right now there is no clarity on that. Okay. But in all likelihood, it would be the major social media organizations, everybody who has probably more than a certain degree of customers, a certain degree of subscribers to that particular social media agency. They would all be significant data fiduciaries.
As of now, we get a lot of calls now from the credit card. So do you need credit card? Do you need to take part in the market participation? How do they get this data? So if I do one-time trading, then every day I get around 10 calls. That are you interested in trading?
Yeah, well, that the whole purpose is that there has been a breach somewhere. The organization since we do not have proper regulations in place, since we do not have proper mechanisms in place, our information is getting distributed like nobody's business, to various service providers, and all of them end up calling us, which I agree is not the ideal state of affairs. And that is basically because the implementation of even the rules under the IT Act has not been effective. So the IT Act has not been enforced, has not been enforced effectively. So with the passing of the data protection bill, and once it becomes an act, it is hoped that measures will be taken to rein in these particular organizations like banks. Most of our information gets leaked out of the banks. For example, even the other day there was this particular speaker in a particular session who was saying that even our passwords have become public information now. It's all in the public domain, and that is the reason why organizations are asking for your OTP, because your passwords are already with the hackers. So just having your password. If it was only password dependent, all our money would have got wiped out of our bank accounts by now. But thanks to an additional mechanism of the OTP, which is being used, which is why our information is still secure. So that is the reality of the situation.
So this is Deepak here. Can you hear me?
Yeah.
So I have two questions. One is like already the social media has a lot of information from our side, and these are already there on the foreign soil. Okay, like a Facebook or Twitter, Google. Everybody has the information, and some of them is also shared. I mean, leaked out, and it's all available on dark web. Correct. That is one thing. And then I don't see like how the user is getting protected, how in the new scenario, because I see like Google is the biggest culprit. Because if I make 2 days back, I just made a search on some medical illness, and then getting emails regarding that from somebody. Yeah, so I don't see like, because it's like your insurance, where you have a big form with 2-3 pages just with the information to be filled, and then you have 5-6 pages with the terms and conditions which nobody reads. Something like these organizations also have big terms and conditions, and you have to say yes or no to full or nothing. So I don't know how this new laws is going to protect us from these social medias.
Yeah, I agree with you, Mr. Deepak, because every law, just passing a law is not sufficient, as you know. There has to be a political will to implement the law as well. But now, given the fact that we are moving towards a completely data-driven economy, and you have more businesses which are online than offline, it is imperative that these leakages are plugged. If
Yeah,
not,
but
yeah.
is there a specific way they're going to handle this? Because it's very vague, right? Let's say how these social media handle our information.
Yes, so which is why these data, the government has probably considered an easy way out by providing such huge penalties for breach, so that these organizations get terrified and ensure that there are no breaches. But in the Indian scenario, we know that having huge penalties isn't really helpful. So we've had in the past huge penalties, huge. Not just monetary penalties, but also other penalties, even under the IPC. But still, crimes are getting committed, and people, are still not very, because there are a lot of loopholes in the system. This is not a Saudi Arabia or a Middle East country where the laws are taken seriously. People know that there are a lot of loopholes in the system. They can circumvent them. But hopefully, we can only hope for the best. We can only hope that the data protection bill, once it is passed into act, will be strictly enforced. And since unlike in the past, these data fiduciaries have huge reach and a lot of influence, and hopefully they should ensure ensure that talk with the government and see that this at least this act is implemented effectively.
Oh, thank you. And how is it different from GDPR? Is it more stricter or it's lenient?
Well, this bill has tried to mirror the GDPR in many respects, especially with respect to the identification of information, with respect to consent. It is trying to mirror the GDPR. So yeah, with respect to consent, with respect to identification information, it is all on similar lines. However, there are certain aspects of it which are not like the GDPR. For example, as I said, the the information on data breach, disclosing of any data breach. The timelines have not been specified. The right to be forgotten, which is a part of the GDPR, is not a part of the data privacy rules as it exists today, because that is an important part which needs to be considered and taken care of under the data protection bill.
Sir,
Thank you,
this
sir.
is Sumit Kochar. Am I audible?
Yeah. Yes.
Yeah, sir, you were mentioning about the location of the data being stored.
Yes.
So, as we all know, the reason is being given that okay, it is economic to store the data in a colder country and all fine. But as far as the usefulness of this kind of law is concerned, as we all know, as somebody else was also telling, that the most of these data giants are located outside, and probably the biggest threat to this data protection of local public is from such giants only. So by exempting such outside locations, does it not make the bill a lame one? How far it will be able to really really help the Indian diaspora?
So as I understand it, your voice was a little feeble, so I will try to repeat your question. So you're saying that information which is kept abroad in the servers, to what extent is it going to help the Indian diaspora in terms of is it in terms of their ability to access information, or could you just repeat that question, please? I think I'm losing you somewhere. Sorry.
Yeah. Am I audible now?
Yeah, you're audible. Yes.
Yeah. What I mean to ask you, sir,
Yeah.
by exempting the outside locations,
Yeah.
is this law not mere a law? Not making a lot of sense, because it makes it very lame, because most of these giants are located outside only, and the reason being quoted for exempting such outside location, that okay, it is economic to store data, servers are generating heat and all that. That is fine, that is a cost of the business. Cost of the business, and they are free to choose their location. But then somebody who is operating for the crowd in India should be answerable to Indian government laws also, irrespective of their location.
Exactly. You're right.
So,
yeah.
just by merely locating their server outside, would they not be taking a loophole? I mean, this is a law being created with a loophole.
Yes. So, which is why the Indian government is saying that you need to keep a copy of all your copy, at least a copy. You can keep you can keep the data outside for all we care, but at least you need to keep a copy in India. So, how this is going to actually pan out and develop is only anybody's guess. So, we really do not know how this is going to develop. But yes, the Indian government has been insisting on keeping a copy of all the records, all the data in India.
Okay. Okay. Thank you.
Yes, sir. I have two questions, sir.
Yes.
May I ask?
Yes, sir. Please.
Yeah. Yeah. Sir, this is first is that basically you mentioned that the personal data is collected in the name of or like business sense or economic sense. So it could be collected, but it could also be collected under the garb of business sense or economic sense. Anyway, so let's not go into that. Now the question is, I'm talking basically of the data retention. Now these data are stored in multiple locations like foreign locations and also here within the country. Now, when we say a copy of it, basically whenever we make a copy of it is actually, there are different servers on which the copy is made. Many standbys are there. There is a main server. There are many standby servers. The standby servers could be 3, 4 or whatever, depending upon the data. So when the data retention aspect comes, like when the data should be erased from all these multiple servers, which are main and standby servers, foreign locations, and the copy of that in the Indian servers, I mean, copy of that in the Indian country, I mean, the Indian nation. So how does an individual or the data principal ensure that his data or her data gets removed from all these storage servers? I mean, who gives the certification, or who is the agency which the person has to get a certification that all his data is removed? Because it is the individual cannot go to each and every server, and I mean that is not possible at all.
Yeah, correct.
So the second question comes out of this only. If an individual or a data principal wants to ensure that all his or her data has been removed from all these locations because of the data retention policy that after so many years or so many, the time elapse of the time, it should get erased or deleted. So if one individual wants to know, how does he approach the data fiduciary? Through an advocate like yours, law firm, or is there any independent direct government channel where I can directly approach the government channel and ask for the certification or whatever it is?
So that's a very interesting question. So this is really, more of a technical, more of a technical challenge than anything else. However, we did have a particular session on this as well some time back. With the industry, industry bodies, and what was actually discussed was that this information which is available on various servers and various locations, probably a copy of it is spread everywhere else, and the data principal doesn't really know where, in which geography and in which location is information is kept. Now, the European data protection regulations have certain rules which provide for the hierarchy of that information in order to be able to reveal to the particular data principal that your information has been kept with these particular organizations in these particular locations, and this is what is kept. So the data principal at any point in time can go either online or seek information and be able to see that. So it is hoped that we do have a similar system in place, which is also an ask from the industry to ensure that the information is accessible by the data principal. The data principal knows where exactly this information is. Yes, it's a very relevant and very very pertinent question, Mr. Sanjay, and I'm hopeful that this is taken into consideration by the by the government. The recommendations have already gone in. I just hope somebody has put in this suggestion as well. But if not, then it has to be taken through some other avenue and brought to the notice of the government.
And how do we address it? Like through a law firm, or there is a government channel? I mean, just to clarify that second. I mean, how does the individual get that ensure through a law firm? I mean, through advocates or through a direct government channel?
The information. So it is hoped that the information is able to get the data principal is able to get the information directly from the organization. So if it is and again from a law firm, I would guess, see, unless there's a breach and unless the person has got badly affected, the law firm really can't do much. However, if the data fiduciary is a government organization, then the individual can, of course, file an application under the Right Information Act and see if he can get that information from the government authority who has misuses information. So that is possible as regards it's a government authority. If it is not a government authority and if it's a private individual, then it's going to be highly unlikely that the data principal will get relief unless there is a breach, in which case, of course, as a private individual, we can apply, we can seek civil remedies.
Yeah, so that is RTI. I am just asking a simple question. If I have to get a certification that my data is now erased, should I go to a government body like a data fiduciary who have got a public interface?
Your voice is very feeble. Your voice is very feeble, Mr. Sanjay. Could you just speak a little louder? Yeah.
Okay, I will try to be a little louder. What I am asking is, I'm not talking about the RTI. I'm talking about an individual wants to find out whether his data has been deleted. So under the data fiduciary, is there a government body wherein I can directly approach them and get a certification, not through RTI, directly through data fiduciary, where I can check with them whether my data has been erased from all the location servers or not? Is there any such provision for an individual to go and, I mean, there is a public interface. I'm talking about a public interface for the data fiduciary.
Right now, there is nothing.
Am I audible?
Yeah.
Okay.
You're audible. No,
yeah,
right now there is nothing. Right now there is nothing. But probably I can take this offline with you, and I can see how far the discussions with the government have progressed with respect to this particular, whether anybody has made this kind of a request, and if it has made that kind of a request, to what extent the discussions have progressed. Probably that can be traced, and I can keep you informed on that. But we need to take this conversation offline for it.
Oh. Okay, so basically it means that as of now, there is no public interface. So I will have to go through a law firm or an advocate. I mean, basically that's it what I'm asking. Thank you. Yeah, thank you, sir.
Yeah.
Participants, you may please unmute and ask your questions.
And just regarding the duties of the data principal, you mentioned some 10,000 rupees penalty. What are the duties like? I'm not clear. Why a data individual should pay 10,000 rupees as a penalty?
Yes. Okay. So I will help you with that. I'll just take you to the 11th provision so that it makes it easier for you to understand how it works. Sorry, but I'm just opening the other laptop. So I know it's a very important question. So data principles shall comply with the provisions of all applicable laws while exercising its rights under the provision of this Act. A data principal shall not register a false or frivolous grievance or complaint with the data fiduciary or the board. So the data principal is not supposed to register a false or frivolous grievance or complaint with the data fiduciary or the board. The data principal shall under no circumstances include, while applying for any document, service, unique identifier, proof of identity or proof of address, furnish any false particulars or suppress any material information or impersonate another person. And lastly, a data principal shall furnish only such information as is verifiable, authentic, while exercising the right to correction or erasure under the provisions of this Act. So it is mostly with respect to the kind of, his conduct. He should not be raising a frivolous complaint only because, he has some kind of a issue with somebody in the data fiduciary. He has to ensure that whatever information that he's giving with respect to his documents, his identity documents, and all of that is authentic. He cannot be passing on any information which is false. So in the event that he does it, then these are the penalties available.
Okay, sir. Thank you, sir.
See, there's one question from the there's one question in the chat box, sir. One Sanjeevani has posted.
Yeah.
For organizations like training institutes, wherein registrations are collected, since when they will have to follow such concern. One. For schools and employees, what is assurance individuals are not exploited? What is the protection? And the last question is, how customer can challenge in case such data breaches are detected? The legal fight can be too costly.
Yeah. So I can see one question here. Is it with respect to without outside installation? For organizations like training institute where registrations are collected, since when they will have to follow consent. Okay. So I'm sure whenever information is being collected by training institutes, they already have some kind of a consent form for collecting information. But the thing is, right now, although the consent needs to be collected and it has to be the consent has to be collected, the purpose for which it is being collected has to be disclosed. None of it is actually being followed. In spirit. It's only the letter that is there. Nothing is being followed in spirit. So at least after the passing of the Act, it is hoped that people are educated on this. These things are brought to their notice and these things are taken seriously. But yes, I agree with you. Right now, many training institutes might not be doing it the way they should be doing it. But this is a story across the land. Nobody is even aware of the Data Protection Act, the SPDI rules. Very few people are even aware of it. Otherwise, we will not be having so much of breaches happening. Without outside installation, except will this law not be a lame one? Without outside installation, yes. I mean, this law has to be enforced. It has to be implemented effectively, and for that, I'm sure now that we are moving to more of an online economy rather than offline one. Everything is going online. I'm sure steps will be taken to ensure that data breaches are not taken lightly. There's also a question on for schools and employees. What is assurance individuals are not exploited? What is the protection? Yeah. So how can customer challenge in such case data breaches are detected? The legal fight can be too costly. So if the school is trying to use that information for a negative purpose, that information is not being used to give benefits to the teachers or to the students, but that information is being used for carrying out a certain other activity which could be detrimental to the particular teacher or student, then right now, unless that school is considered as a significant data fiduciary and you have a data protection officer to whom you can complain, right now there is no way that you can complain to the school, at least under the act, even after it becomes an act, and you will have to treat it as a breach, and you will have to uh, go under the authority who is specified under the act. So there is obviously, these things are not outlined as yet, but we are sure that with the act coming into force soon, we will know which who would be the legal enforcement authority in case of a breach under the act.
Thank you, sir. Anyone else has a question from the participation side? You may please unmute and ask.
Hello, this is Deepak here again. One more question.
Yeah,
We're talking about implementing this thing,
Yeah.
but I feel some of the things are legal thing which even the legal institutions are not have a clarity. To give an example,
Yeah.
currently government has said that you need not share the complete. I mean, if you give a copy of Aadhaar, it can be masked Aadhaar. It need not be a complete full digit
Correct.
Aadhaar number.
Yeah, yeah.
So, but I went for a property registration. So they were anyway taking a thumb impression and doing a Aadhaar verification. But still they insisted on getting a photocopy of the Aadhaar card with the complete 12 digit. And that which I have to, they don't do it. They ask me to go and get it outside. So again, why these things are happening?
Yeah. So I agree. This there is a lot of mug up with respect to the whole thing. They should not be asking you for the entire Aadhaar number. They should only ask you for the masked Aadhaar number. But at the end of the day, you can, of course, you can make a complaint. You can raise a complaint to the authority under the information under the IT Act. You have the CIO, Chief Information Officer, so you can make a complaint there. But how long it's going to take, how long this whole thing is going to, because at the end of the day, we go to a particular enforcement authority, we go to a particular government to get our job done the same day, or probably maximum 2 days. But this kind of a thing can take its own time to get resolved if you make a complaint. And the repercussions of that, how it is in the Indian scenario. So yes, I've also faced this challenge, but I can't give you an immediate answer for this because this is
is the government also planned for any training of things so that this gets implemented smoothly, or just the order passing will be enough?
Yeah, the data protection bill doesn't talk about any education as such, but that is really going to be the data fiduciary. Even the for that matter, even the UID is a data fiduciary. So there should be a way in which we can complain to the UID and tell them that this kind of information is being asked, and yes, that is one way of doing it. You will have to actually approach the particular relevant authority who is actually processing that information and say that this information they're asking for, this entire information which I'm not supposed to give. So it really has to be handled at that ground level more than anything else. We can't take these kind of matters to the court because the resolution is very long-winded and not really effective in that sense. So at the most, what you can do is this, but we hope there is a more effective data protection implementation authority. We have something called the board, the data protection board under the bill. We just hope that the data protection board under the bill is able to take care of these issues and able to give a solution. But it's again early days to say anything, since the number of people who are going to be involved are going to be very powerful, and it will be good for them to keep to have a system which is effective. Hopefully, the act will take care of these concerns and make life easier for all of us.
Will there be something like an ombudsman for this?
Yeah, you have the data protection board. We have the
Okay.
data protection board under the data protection bill, which will be in place. Yes.
Okay, thank you.
I think just now Deepak had brought out the issue about the photocopiers. Now we find photocopiers in every nook and corner. Now these are the latest photocopiers. They can actually store data with them. And there have been cases where data breaches have taken place, where some of the photocopiers have passed on data like PAN number, Aadhaar numbers, what do you call, bank details, etc., to unauthorized people, I mean, which is not supposed to be done. So photocopiers regarding, is there any regulation? I don't think any regulation is there, whether to erase all the data which they have. Like some people do it, but it is not necessary. I mean, is there any regulation regarding that, regarding photocopiers?
First of all,
I'm talking about digital photocopiers. Yeah, digital photocopiers.
digital photocopiers. Okay.
Yeah, from where the data breaches take place.
Okay. Okay. So when you go to a particular shop for photocopying, you're saying that particular from that particular outlet, the information is getting stored. Is that what you're saying?
Yeah. There are some storages, or he can immediately after you go, he can take copies, more copies of that. You ask for 3 copies, he will also take 1 copy separately. I mean, after you go away, because it's stored there temporarily in the memory.
Okay.
So this, yeah, there have been cases I have seen. I mean, that's why I'm.
Yes. So definitely. He's a data processor for all purposes. As a data processor, since he's taken copies of your information and given it back to you for the particular purpose of your need. I'm sure action can be taken against all these people. So these are all. So there are huge challenges when it comes to keeping comes to handling private data in India. I think the largest challenges come from the banks, which hold enormous amount of private data and who are giving out our private data left, right, and center to everybody who's asking for it. You also have this information flowing out from different kinds of financial institutions, like stockbrokers, like brokers, basically brokers.
But then also RBI is coming up with some draft regulation, IT governance regulation, something like that. Is it they're changing the bill for that? Actually, I could see draft master direction of information technology governance, risk, and issue practices from RBI.
Pardon me?
No,
I didn't get that.
No, the Reserve Bank of India is coming up with any kind of change in their policy on management of this information.
See, the Reserve Bank of India will also be governed by this particular act once it comes into existence. The Reserve Bank of India has its own rules on handling data, which it follows. But right now, since there's no overarching act in place, each of the bodies follow their own rules on data protection, which at an organizational level they follow. But I think once this act comes into existence, this act will be the overarching act and will override every other rule that has been put in place by the individual regulatory authorities.
Okay.
So Rajendra Sapre, GK, any questions?
Nothing from my side, sir. Good. This was a very interesting session. Thank you.
Rajendra?
Sir, I'm good.
You're good. Okay. Thank you, Rajendra.
Yeah.
So anyone else has a
Great
question?
session.
Please ask a question. We are coming to the end of the session. So if anybody else has a question, you may please unmute and ask your question. One last question we can take.
Actually, Mr. Gopi, we should have another session after the probably after 6 months to 8 months of the act coming into place, because we will then know what are the successes and failures of the act. Because right now we are speculating a lot, and of course it is not giving any of us the comfort whether things are going in the right direction or not. I can also sense that discomfort among all the participants. But hopefully we will have more
clarity.
More clarity once the act is in place for at least 6 to 8 months, and we will know how good or bad the act has been working, and we will be able to give more concrete fact situations, and that will be more helpful for the audience.
We'll do that, no problem.
In India, the making law is very good, but is a major problem.
Tirupati, we lost you in between.
No, what I'm saying is, in India, we make very strict laws, but implementation becomes a very
Yes, yes, very true. Yes,
problem.
yes, yes. Yeah, very true. There is no will to implement. Everybody, after the act is enacted, they started looking for loopholes.
Correct.
And there is no one enforcing body which ensures that irrespective of the loopholes, the act is implemented. So, of course, it makes a lot of monetary sense for lawyers like me, but for the general public, the general public still suffers because of this issue.
Correct.
So thank you very much, Mr. Christopher. We had a wonderful session today.
Thank you, Mr. Gopi.
Yeah, so we will stay in touch with each other, and we'll see how to take it forward in the coming days. And whatever queries are there, I will also try to get in touch with you for the clarification that people like Sanjay might want, or Sanjay, Tirupati, Deepak, and others would ask questions.
Sure. So yeah. I'm in touch. So of course, you can get my contact details from you.
Yeah,
that's not an issue. If I have to share the PPT, please let me know. In fact, you already have my PPT. So,
I already have it.
Yes.
Great. Thanks, Mr. Christopher. Thank you.
Thank you.
Thank you, Christopher, for joining us once again.